Hi, I'm Greg Dell, and this is Alex Palamara.
Good afternoon.
And we are going to discuss today the importance of preparing a ERISA appeal for a long-term disability claim. And the reason this has come up is that we get calls from probably well over 100 people a week discussing how they have an appeal to file because they've been denied, and they want to know what to do, with their appeal. And then we also have the whole gamut of people who say, I did an appeal because the carrier called me and just said, go ahead and send in telling us you want to do an appeal. And I want to discuss the disadvantages of trying to do your own appeal.
Well, first and foremost, that's a great point that you bring up regarding the insurance company telling the claimant, oh, just tell us you want an appeal and we'll do the appeal, we'll look at your case again. But I think that's kind of crazy because you're asking the same entity that just denied your claim to use the same information they already relied upon. They're just going to deny your claim again, and then you're out of appeals and you're left with a lawsuit, which is horrible because at that point you didn't use your appeal to strengthen your claim file. So an appeal does a few things. It allows you, one, to challenge the decision by the insurance company that just denied your claim, and it allows you, second, to submit more information into your claim file to either overturn the claim or at the very least give you a stronger chance at winning a lawsuit. Now, it's your responsibility to provide proof of loss for your claim. Not the insurance companies. They may promise you, hey, give us your doctor's information, we'll go get that, all your medical records. They can promise you that all they want. It's not their responsibility, it is your responsibility. So you have to provide proof of loss. Your only time to do that is while your claim is pending or during the appeal stage. So if you file an appeal with no additional medical records, no additional letters from your doctors, you're basically just filing, a piece of paper that's going to waste your time and make your claim harder to win at trial.
Right. I always tell, without offending people who call us, I say our job is to, and your job as a claimant is to make yourself look messed up on paper.
It's true.
And the reason for that is that when the disability carrier gets your information that you're sending them, they're probably not going to call you. They're probably not going to have you examined. They're just going to send whatever you sent them out to some random doctor who they've probably worked with a couple hundred times, and your case is only as good as it looks on paper. So unfortunately, you as the claimant are concerned about trying to get yourself better or trying to control your symptoms and be able to treat whatever medical problems you have, and your doctors want to do the same for you, but they're not really looking to document your medical records such that it's going to be reviewed by a disability company. So that's where we offer a lot of help in really making sure you see specific doctors that can really document the medical conditions, and also working with you and your doctors to make sure that the medical records say the things that they need to say.
Right.
So one of the things that I always like to tell claimants is you have to review those records with almost every visit that you go into, and when the doctor says, how are you, even if you're having a good day, that doesn't mean everything's great. You have to list all of your complaints, and you have to make the doctor write them down in the records. But what's an example of a situation where, like just last week you had a case of mediation and the claimant had numerous things wrong with her, but what did the medical records look like?
Well, unfortunately, she filed her own appeal. Her appeal was, it's a couple pages long. It really touched your heartstrings. It made you feel horrible for this person, but she did not file any additional medical records with her appeal. So she came to us after her appeal was denied. We filed a lawsuit for her, but the lawsuit's only as strong as your medical records. And I looked at her, I talked to her many times, met with her in person. I knew she was disabled. It was pretty clear that she was disabled. But as the old saying goes, it's not what you know, it's what you can prove. So she really needed stronger medical records. She needed to go see her doctors more often, go to her specialists more often, and she needed to get those medical records into the claim file. She needed to review those medical records to make sure everything that's in her medical records is correct. Sometimes doctors, they see, I don't know how many patients per day, but they move on to the next patient. They don't realize what they're putting in their medical records, even if it's, wrong, can have a severe impact on your ability to receive your monthly benefits from the insurance company. So it's very important to always update your medical records, always submit it to the insurance company so you can prove your case. It's what you can prove is how you're going to win your lawsuit or win your appeal against the insurance company.
And then, you have a claimant who's been on claim a couple of years and they just go to one doctor, and then that doctor has medical notes that may not even be legible,
Right.
or isn't documenting all of the issues, and then some new claims adjuster gets on the claim, looks at it and says, I don't see enough medical support here, and miraculously thinks that after 4 or 5 years of being disabled that the claimant's all of a sudden better.
Right.
So, that happens all the time.
They can lull you to sleep, and you stop going to your doctors more often, or as often as you should be, because you've been on claim receiving benefits for 2, 3, 4 years, and you say there's no reason for me to go see my doctor so often because I'm not getting any better. So instead of going once a month or once every 3 months, now you're going once a year, and out of nowhere they ask you, a new claims handler becomes involved, asks you for updated medical information. You go, oh geez, I haven't seen a doctor in 9 months or a year, and they use that as justification for denying your claim.
All right, so if you haven't filed your appeal yet and you're watching this video and you're thinking about hiring a lawyer, we would love the opportunity to discuss your claim denial with you, and we'll let you know how we can help you. If you've already filed your appeal and you've been denied, you still have opportunities to potentially win your case. We're certainly going to look at the case and let you know, because just because you didn't submit a great appeal on your own potentially and the disability carrier denied you doesn't mean that you don't have a leg to stand on to possibly win. The disability carriers, fortunately for you, are really bad at reviewing disability claims, and if we can prove that they acted carelessly or unreasonably in the review of your claim, then it's likely that we would be able to win your case at a lawsuit and get your benefits paid, or at a minimum, get it remanded and at least give you another opportunity to submit a sufficient appeal. So we look forward to the opportunity to speak with you.